welcome to a special edition of Murphy's Law Podcast. I'm your host, Ian Murphy. With me today again is Chris Kuhn. He's been following our case and some adjacent cases as well with regards to the school mask mandates and some of those other things. He watched the entirety of our hearing here in Otsego County that happened Monday morning around 9 o'clock, where we were able to finally, just a year or so after we were charged with a violation, we got a chance to argue why we think that the health code section 333.2253 is unconstitutional. The 3 paragraphs, the 1 page. So what we have is an okay recording of an external recording of the Zoom hearing. Unfortunately, they took down the YouTube link about 2 hours after the hearing. Very quickly. It seems like that is standard procedure for these Zoom hearings. We wish it wasn't, as more people would be able to hear and see what is going on in some of these meetings and hearings. So that's a discussion for another day, but it's interesting how these things seem to be taken down. Again, don't read anything too much into it. We had a good day in court. We were fortunate to be in front of a very smart judge who has had plenty of background on this case. So what we've got is a recording. They did not allow me to screen share from the beginning, so it catches in about 5 minutes in, where our attorney, Dave Delaney, is discussing why, I shouldn't say discussing, is actually arguing why MCL 333.2253 is a violation of the non-delegation clause of the state Supreme Court.
You might want to consider getting a tattoo of that. There you go.
I don't have a single tattoo, so that would be the first one. My wife might have something to say.
I might have to insist on risking for the brisket personally, but
that, it's probably a good idea. I think I know the guy that has the logo for that. Either way, we're going to catch up on this. It's a few minutes in. Hopefully you can hear well enough. I'll try and put the mic over here so you can catch what's going on.
To the extent that you do have activity in that restaurant, masks are required. 6 feet of social distancing, 10 p.m. closing, 9 p.m. closing. That was a moving target all the time. 25% capacity, then 50, and the Iron Pig, Ian Murphy.
Oh,
you can make that up as a story.
By the way, every time they say Iron Pig in this, we have to drink it.
Oh, we're behind a few.
So there's at least one, so we probably need to, there's a couple in there, but anyway, sorry.
Collect the names and contact information of its customers.
Or when my mail
Now, maybe those are all good ideas, Judge, for the pandemic, but they're not in the statute. And there's no remedy for the Iron Pig here. There's no elected official that you can contact. This is an agency of the executive branch that is writing the law and enforcing the law.
That's the key.
And that becomes the issue in this case. Much discussion was addressed in both briefs on what James Madison said, the founder of the Constitution in the late 1700s. And that's tyranny, Judge. And that is the executive branch in this case had both powers. They had the power to write the law, and they had the power to enforce the law. And they wrote them at will.
That's my dad.
They would change at midnight. The next day, we'd get new orders from the executive
You'll
branch.
hear some sarcasm in this, too. I'm just warning.
And so the power was in the same hands, and that became the issue of the non-delegation in this case. And, Judge, an issue that was not addressed by the state, which is very, very critical, is that these are criminal laws. The Michigan Public Health Code, if violated, is a criminal law. Now, were they arresting people? No, but it's a threat, Judge, that is up to a 90-day misdemeanor, or 91 days, whatever it is in this case.
It was a threat, yeah.
That has to come from Congress. If Congress wants to draft a criminal law, we would know. The Iron Pig did not know when they opened their restaurant that the Michigan Public Health Code could close his restaurant. If that were in a legislative mandate, specifically stating that, then he would be on notice. The other thing is, Judge, that the statute does discuss an epidemic. Clearly, we're in an epidemic, a pandemic, but the question that people ask is, when will the emergency be over? That was actually asked by Justice Barrett in the U.S. Supreme Court on Friday. And that becomes the issue in this case. And there are 3 prongs, and I'm certain this court is always very thorough in its preparation for oral argument in cases. But the 3 issues are the adequacy of the standards, the scope, and the duration. So, as the court is aware, the legislature can give some delegation to the executive agencies. They have to have some authority. The Secretary of State has to have the ability to issue driver's licenses and determine when they expire. And so there is some allowable delegation, so long as there's genuine guidance, intelligible principles, and the employee doesn't have the free rein. They have to be constrained in a meaningful way. In this case, Judge, there are no standards. The state will argue that the word necessary is in there, but actually, Judge, it's a few words back. It just says necessary when there's an epidemic, necessary to protect public health. Well, that's extremely broad. But it's the next sentence, Judge. By emergency order, the prohibition of the gathering. Even if we were to move the word necessary over to that language, that when necessary, the director may prohibit the gathering of people. Well, that does tighten the reins just a little bit. But remember that the in-rate certified question, the anti-rioting statute from 1945, contained the words reasonable and necessary. And quite frankly, I thought that that statute before the decision could survive on those terms. Those terms are common in the practice of law in legislatures, but it didn't make it. The reasonable and necessary standard was insufficient and did not provide the intelligible principle. If the 1945 cannot survive with reasonable and necessary,
here it is.
Then this statute from 1978, with just the term necessary, cannot survive. And this is clear stare decisis in this case from 2020 on a pandemic-related issue. I don't know that the court could have more relevant precedent in this case. And the next is the scope, Judge. The state cannot dispute that the indoor dining mandate extended from Detroit to Calumet. So this was not just a Gaylord mandate or an area of the state, and let's assume that the pandemic was more susceptible to some areas of the state than others, near water, whatever it would be, a contagious disease. But it wasn't. And then duration, Judge, the indefiniteness of it. That's a crucial issue. For example, the Emergency Management Act, as opposed to the Emergency Powers Act, the powers was struck down, the Management Act survived. That had a 28-day limit, and then it goes to Congress. So it does force Congress and the executive branch to work together. But
this is what we've said from the beginning is the proper way that she should have been doing things.
Checks and balances.
28 days, keep the legislature involved. They argued in Carl the Barber's case that the legislature couldn't act quick enough. So therefore, the governor and the executive branch needs to intervene and do these things because they can't, in 2020, can't act fast enough in a time of emergency.
But again, as we were talking about before we started, that was the act of 1945, 75 years ago, no cell phones, no Mackinac Bridge. There's a reason for that Emergency Powers Act.
Right.
They had to give the governor power to make decisions and take action while the representatives were being contacted and giving them time to get down to Lansing to convene. Far cry from 2020 when this all started.
Yeah, exactly.
No limitation here, Judge. This indoor dining mandate went on for months and months and months and can be activated. It can be activated right now. The other issue, Judge, and I don't think it was necessary to brief it, but I want to point it out to the court, is that the Attorney General's office is saying, well, the director has this power, and that is true. But Article 2 of the Michigan Public Health Code is divided into two sections, the state section and the local section, and they are the same. So, for example, a local health officer could then, in the language is nearly identical, in a pandemic, in an epidemic, prohibit the gathering of people. So it's not just the director that has the power. Although in this case, the power was issued from Lansing under the directorship. But I just wanted to point out the expansiveness of the Michigan Public Health Code.
We see some of that now with the mask mandate cases for schools.
And was not before me all the time until recently when this case developed. I did want to indicate, and it's clear in the Attorney General's brief, they believe the in re certified question was wrongly decided.
Naturally, they're going to say that.
Of course.
So every time you hear the mention in re certified questions, that's Carl DeBarber's case that knocked down the emergency powers of the governor. Let's take a really quick break here. We'll come back and we'll play some more of this.
Meet your friends to watch a big game at the Iron Pig Smokehouse in downtown Gaylord. The Iron Pig has a full bar with 8 draft beers on tap and features signature cocktail flights. The Iron Pig Smokehouse for breakfast, lunch, and dinner. Available online at ironpigsmoke.com.
All right, welcome back to Murphy's Law Podcast. Special edition discussing our hearing from Monday morning with the Department of Health and Human Services. We were just discussing briefly Carl DeBarber's case that our attorney was talking about here. Let's see what else he's got.
Well, the only thing that can happen there, Judge, is a reversal by the Michigan Supreme Court on that issue. And they point out it was a 4-3 decision, as are many important legal issues.
So what he's actually referring to is the state has made the point that they disagree with the state Supreme Court's 4-3 decision to knock down the Emergency Powers of the Governor Act, which Carl DeBarber, he challenged that. So naturally, of course, they're going to disagree with that.
Are decided by 4-3. Effectively, Judge, if the 1945 is good law, that case, then so too must the court follow that in this case as stare decisis. I don't think we can do both. I don't think we can respect the stare decisis of 1945, but find that this statute is not an improper delegation or a non-delegation from the legislative branch. And I think that the legislature does not intend to delegate these powers. But in 1978, Judge, I don't think we had any pandemics at that time. It was just an upgrade from the 1918 law from the Spanish flu. I want to point something out, Judge, in the in re certified question decision. It's on page 14 of that decision, in which Justice Viviano was talking about the 1919 law. 1918 was the pandemic. And in that case, Judge, there was a similar restriction as we have here, except that it related to public meetings. That's what the restriction was tied to, not necessarily the gathering of people. And that's such dangerous language, Judge. If I'm standing at the bus stop talking to somebody, that's 2 people, that's a gathering. That's what the order says from the director in this case.
Which is a great argument.
But what's of note, Judge, is that
Scope
when
and
you look at
limitation.
page 14 and they cite that statute, not only does it restrict public meetings, it then goes on to say that the order must be signed by the health commissioner and countersigned by the governor. So even back in 1919, Judge, they had somebody else having to weigh in on the statute in this case. And then it says that the action of the director of the Department of Health, whatever that title was back in 1919, he could not take that action, or she could not take that action without the consent and approval of the Advisory Council of Health. So the legislature didn't carry that language over into the 1978 statute. Had they done so, the statute might have had more delegation legs, but it doesn't. The director is the sole decider of when and where and how these orders get issued, and it's indefinite. The 4 or 5 page order in this case has definitions. It can tell you when to close your indoor dining, the time, and the collection of information, and none of that is in the statute. The other matter is Judge's remedies. I have a number of other health department cases involving schools and masks, and and the great concern is that the court would be taking away power to deal with a pandemic. I know this court takes it very seriously. I don't believe there are trials happening in your court because of the pandemic, so I know the court takes the health and safety and welfare of its citizens very seriously. But the idea becomes, when I argue this case, is that if you take the statute from the state of Michigan, that's it. We don't have any remedies. People will get sick. There'll be nursing homes with disastrous results. And that, I just disagree with that. And it's not my opinion. For example, the executive branch still has the 1976 Emergency Management Act. Right now, the governor can declare an emergency, close the courts, close the schools, close restaurants, and it'd be lawful. And that's addressed in the in re certified question case. But after 28 days, the legislature gets to weigh in.
That's where we fundamentally have disagreed from the beginning.
Correct.
Even when she issued the emergency orders, the executive orders, we just knew that something wasn't right. How could this one person unilaterally do this forever?
Well, and not only that, it was a constantly moving target, as Dave pointed out. It was, we'll try this. Well, hang on, now this. Well, hang on, now this.
Right.
So you didn't know from day to day what the rules were. How do you follow that?
And we had no recourse. We had nowhere to go. We couldn't call up our legislature and said, "Hey, when the 28 days is up, we need you on our behalf to say this is not helping, this is helping, or we need this relief, or we need that relief." We were never given that opportunity. And people forget that when she did the executive orders in March of 2020, she also, after 28 days, violated the EMA. And people forget about that. So they knocked down the EPGA, the Governor's Act, via the in re certified questions in front of the state Supreme Court, knocks that out. Then they pivot to this health code, 333.2253.
Which, by the way, we've talked about is literally 3 paragraphs.
Yeah.
I mean, look it up. MCL 33.2253 is like 3 paragraphs and actually references the avian flu.
Yeah.
I mean, so...
Versus 45 pages, and I forget, I used to have the stats on how many words were even in that 45 versus 2253 that they're trying to use, to still use, honestly. Because today,
go back to it.
Today, today's Tuesday, right?
Yeah.
The State Board of Education had hearings today on a resolution citing this exact same thing that we just argued yesterday is unconstitutional.
Well, and a lot of these very same issues are, if you haven't been following, are going before SCOTUS or went before SCOTUS on Friday.
Right.
And a lot of these same briefs that were filed and the same arguments made with the Supreme Court of the U.S. And it's going to be interesting to see what the findings are out of that. Because it's a lot of the very same issues.
I thought they were going to have them already.
I thought for sure.
I thought Monday morning they would have released them.
They said there was 2 coming today. They didn't give any indication.
Well, we'll see, because not only that, it'll give guidance to thousands of cases and lawsuits that are out there. To speak nothing of what it will do in our state alone, further bolstering our case, because we already have the in re certified question in our back pocket, which of course the state thinks was wrongly decided. Mm-hmm. I mean, of course they think that. If we win on this, they're going to turn around and say that this was also wrongly decided. So,
and don't think I didn't notice the fact that you had the suspended license.
There's actually 3 Easter eggs in that thing right there.
We'll talk about those.
So we'll come back to that.
Therein lies the balance that James Madison sought between at least two of the branches of government. So that protection is there. Also, under the Michigan Public Health Code, Judge, one section back from this section, this is 2253. The 2251 is the imminent danger section. So if the health department determines that there's an imminent danger, they can take action there. But a
lot of people actually don't know this, but we argued early on in this whole thing, the imminent danger. Yeah. They could not prove that there was imminent danger,
and still couldn't today.
Now they still, they can't, and they never will. It's on record that we don't have.
And they had, I remember that tracing. They had no definition. They had no way of expounding upon imminent danger.
One of the greatest things was them having to admit on the record in one of our early hearings that there has been no contact tracing. And that stemmed from the whole thing about the imminent danger and all that nonsense. But let's take another quick break here, and we'll be right back.
The Iron Pig Smokehouse in downtown Gaylord features low and slow barbecue beef brisket, pulled pork, and chicken. Order a delicious burger, pizza, tacos, and more at the Iron Pig Smokehouse. Open for breakfast, lunch, and dinner. Dine in, take out. Delivery available at ironpigsmoke.com.
All right, we're back on a special edition of Murphy's Law Podcast. I'm your host, Ian Murphy. Chris Kuhn is with me. We're just discussing briefly Monday's hearing with in front of Judge Colin Hunter here in Otsego County. Our attorney, Dave Delaney, giving oral argument presently, and then the state's Assistant Attorney General, Darren Fowler, is coming up here in just a moment.
You're going to like this.
Due process component, which allows the Director of Health to take someone to the circuit court, the district court, probate court, Ingham County Circuit. There's a lot of remedies there. But it gives the person on the other side of it some due process, a notice and an opportunity to be heard. When you look at 2253, there's none of that. There isn't any remedy for the Iron Pig to defend itself on whether or not this order should apply in this case.
No,
and that's the reason the Liquor Control Commission, the Department of Agriculture, MIOSHA, all those organizations fined him, took his licenses, and there was simply no judicial remedy available at the time. In addition, Judge, and I cite them in my brief, the County Board of Commissioners locally, township boards, cities, villages, and your state and local Congress have ample power to deal with the pandemic. And another crossroad, Judge, is the private sector. They want to say in this too, they feel like they can assist with the pandemic, that Mr. Murphy knows how to run a good restaurant. He knows how to keep it clean. He knows how to protect people. He can decide if he wants them to wear masks. He can decide if he wants his employees to have vaccines. But let that come from the private sector. And many of them repeat what's been said by politicians before, that government is not the solution to the problem. Government is the problem. So, Judge, in conclusion, I would defer to James Madison in the first three words that he placed in the Constitution, and that is, we the people, followed by, to secure the blessings of liberty. And as the federal courts are saying, there is no pandemic exception to the Constitution. Thank you, Your Honor.
Thank you, Mr. Delaney. Mr. Fowler or Ms. Moo, who's going to make argument on behalf of the state?
I will, Judge, and thank you.
Thank you.
Judge, I think it's useful to take a moment and look at the context in which this appeal to this court arises.
Right.
This is not a brand new lawsuit. Iron Pig didn't file a lawsuit when it saw an order come into place that it felt it could not operate under. What it did was ignore the law. This matter arises from an administrative proceeding where an administrative law judge upheld a $5,000 fine imposed against the Iron Pig. Why? Because the Iron Pig, back in November of 2020, during the first year of this pandemic, at a time when vaccines were not available to any of us, made a decision that it was going to do what it wanted to do, no matter what was written in Section 2253 of the Public Health Code.
Which you communicated, by the way.
I
can't help it. They already said that.
It went on its Facebook page and said, "We're doing what
You're
we
an ass
want."
for that. A lot of other things
Listen,
too.
I got to tell you that the amount of attention that they it cracks me up. I have never seen. Of course, I don't read a lot. So, yeah, I don't. The Facebook stuff just cracks me up. There's too much to it. It's so funny. They basically just go to our Facebook page and they think that that's their investigative work. So
I'm glad they're following.
That's part of the reason why we just make continuous jokes about all of it, because we know they're watching, and it's funny. They were looking at my personal Facebook page for a while too. The times that we live in, nothing surprises me anymore.
Open, come here. The owner went on the news and said, "We're going to do what we want. Never mind the law.
I do what I want.
Come here." 5 different days in November of 2020, That was documented by local health officials and by police officials.
Which I want to point out, you
Open and
contacted
operating
them.
My friends.
and allowing
By
the
the way.
spread of a disease that at that time people could not protect themselves from through vaccines. And we all know from our experiences over the past two years that this is a disease that isn't limited to spreading inside any particular building or under one roof.
Just not box
That when
stores.
one person gets it somewhere else, that we've all been in danger of getting it when we talk to that person in our homes or at work. So the administrative law judge looked at the evidence in front of him, and Judge Kibitz said, I see that this entity was operating, that the Facebook page shows it.
First off, the first thing to notice right away, it's all about Iron Pig and what we did. He's not addressing anything about that question at hand. It's all about
nothing
how
about the MCL.
bad, how nasty, and how terrible we went on Facebook, and then we went on the news and decried about
And
it.
again, I want to point out to everybody, you contacted our local official before you did so and said, listen, I'm going to open.
Yeah, the day
So
before,
the-
I let our local
The
health
news was not
department
the
know.
first. The news was not the first time it got out. You contacted them directly.
Yeah, they were here at 10:40 in the morning, 20 minutes before we opened, giving us the So
Yeah.
I mean, that's no surprise.
Operating, that it was on the news saying it was operating. And so this fine of $5,000 should be upheld. And the
You're
Iron
so
Pig
butthurt
now
by the
has
Facebook
brought to
page.
you
Yeah,
this
that's the whole
indisputable,
research team right
This is
there.
why I
Fine.
can't sit in court.
this
you post
indisputable
Anybody
operation,
else.
and is trying to convince this court to set aside a law that it has decided it does not like. I think it is useful in reflecting on the extraordinary relief that the Iron Pig is asking for from this court.
Extraordinary?
To look at page 2 of the Iron Pig's brief related to the non-delegation issue. There, the Iron Pig, as it must, acknowledges, quote, any power that the legislature gives the other branches of government.
This is what I was
they
talking
can
before.
freely
Yeah.
rescind,
They're trying to use our argument
modify,
against us.
or limit.
Yeah, it's
The
their
legislature
yeah, but
makes
Yeah.
the laws. The governor and the courts follow them. End quote. That's from Iron Pig's brief. The Iron Pig is acknowledging that if
Like
someone
5 drinks
doesn't
ahead.
like the law, they can go to the legislature and ask the legislature to
But
change the
you
law.
didn't go to the
The
legislature
Iron
and
Pig
ask
is
them.
He also
acknowledging
mentioned the
that the
judicial,
governor
which is what we're
and the
doing.
courts
Right.
must follow the law. But the Iron Pig is here saying, Judge, we don't like 2253. We acknowledge it's been on the books since 1978, and we haven't come to the legislature and gotten a change. We're coming to you, Judge, and
Because
asking
we were studying
you to rewrite the
MCL
law.
for
A
But in their own brief,
43-year-old
they say the
MCL.
courts follow the laws. So they're trying to invent legal theories to try to convince a court to do something dramatic, to rewrite a law. This court should not buy into Iron Pig's effort here.
That's not how that
The
works.
Iron Pig has made 2 different arguments. One on this need for
By the way, this is one of the
hearing
best
to
the
promulgate
state has
this
to offer.
concept. And that is, as Mr. Delaney
It's better,
acknowledged,
yeah.
a process that takes time.
Notice his
is
laugh.
cumbersome,
He does
and it is
laugh.
not conducive to the situation of an epidemic. More important, or just as importantly, the law wasn't designed in an epidemic to require such a time-consuming process. The legislature, in its wisdom and to protect the people of Michigan, told the director that he or she can do these orders through emergency order. That is the exact phrase used in 2253. That is a permissive grant of authority to the director, which is precisely the kind of exclusion the legislature anticipated in Section 7 of the Administrative Procedures Act, Sub J, when a agency exercises permissive authority under a statute. There is no rule promulgation requirement, no hearing requirement. And we can see in the context of
So part of what he's trying to explain is, we mentioned it before, under the executive orders that were used, the legislature can't act fast enough.
Right.
And one of the biggest reasons that they say legislature can't act fast enough is because of the Open Meetings Act, which requires X amount of time to to post that you're having a meeting
Yes.
and all that. They're again, I'm not a lawyer. I just play one on TV, but I'm going to tell you, there have been instances where they're overlooking that. But again, 1978 is when this was written. So at the time, we didn't have text messages. We didn't have the internet
before
as
it
it is
came
now.
live. 43 years ago. So they're trying to hold on to things that, one 75 years old that got smacked down, another one 43. So right now we're again talking about something that's 43 years old. Pre-internet, pre-texting, pre-cell phones in general, let alone iPhones. And they're just clinging on to that with the yeah but, and it gets worse. So listen up.
Academic, why the legislature would grant that kind of authority to a health director here. On the non-delegation issue, Mr. Delaney very much wants this court to focus on 7 or 8 words in the statute to prohibit gatherings for any purpose.
There's only about 35 or 40 in the entire one.
Starting with that, to prohibit a gathering for any purpose includes prohibiting gatherings at restaurants for indoor dining. Now, Mr. Delaney suggested there was something deficient in that statement because it doesn't say anything about restaurants. But the clarity, the conciseness of this statute that it...
Hold on. He's about to actually make our point for us.
Yes.
If you catch it.
He's doing a good job.
Existing for a very important purpose to protect you.
Remember, he's about to say the words concise. Let me back it up just a hitch because he says the words concise in here, and there's nothing concise about this statute whatsoever.
Now, Mr. Delaney suggested there was something deficient in that statement because it doesn't say anything about restaurants. But the clarity, the conciseness of this statute that is existing for a very important purpose to protect human lives in the face of a pandemic is not one that needs elaboration of every kind of effective business. It would be frankly absurd to put that kind of requirement on the legislature to list every conceivable kind of business for fear that it would miss one, and then then people in a particular area would not be protected. More importantly, Judge, the rules of statutory construction require looking at all the words.
They didn't limit the gathering of people at Walmart.
That the Iron Pig would refer the court
or any box store.
The statute clearly anticipates and says that when the director determines that the control of an epidemic makes it necessary to protect life, that these types of limitations on gatherings can be done to protect people. And what the legislature was doing in that statute was emphatically what the people of the state of Michigan told the legislature it must do.
No, they
in Article 4, Section 51 of the Michigan Constitution, where the people of Michigan, speaking through their Constitution, emphasized that the health and welfare of the people of this state are matters of primary public concern. And then in that same constitutional provision, the people charged the legislature with enacting laws exactly like 2253 to address what we all know is the most serious
I bet
threat
every one of you have
to
texted
the
more
entire
today
state
than what the
of
length of
Michigan
this
and the lives of people here as a whole.
COVID,
An epidemic because unfortunately we've seen that playing out over the past couple
That's
of
what they
years.
do.
More than 27,000 Michiganders have now lost their lives to this virus. The Michigan Supreme Court has set out an analytical framework for how to analyze statutes under the non-delegation doctrine. It did that clearly in Blue Cross. It said, look at the context, presume that the statute
Did you catch that? He mentions the Blue Cross Blue Shield
analyze
case.
the standards. The Iron Pig prefers to try to point to other cases that are going on rather than asking this court to focus on the standards in section 2253. So the Iron
There
Pig
are
talks
none.
about what the U.S. Supreme Court is doing on vaccines under the Commerce Clause, which is